Thank you, ladies and gentlemen, for joining us today at the University of Essex, Angels at Essex University Enterprise Zone, where we will be discussing intellectual property and all the associated words which go along with it. It is quite a complicated subject, and we have got a panel of experts here today, which we've lined up especially for you. So I'd like to introduce the panel today. First of all, I have with me Emma Richards, and Emma Richards is from the Intellectual Property Office. Now, that is the office where you get the advice, and they have their own website and can help and support you going forward. Would you like to say hello, Emma?
I've been working at the Intellectual Property Office for nearly 23 years now, so I've got a little bit of experience in the area. My most recent role generally takes me out on the road, giving advice to people like yourselves, and giving them the right platforms and the right advice around where they need to be with their intellectual property. So that's what my role is within the Intellectual Property Office.
I'd now like to introduce James Sanderson. James, would you like to give a quick introduction about yourself? Thank you.
I'm James Sanderson. I'm a senior partner at a firm of patent and trademark attorneys based here at the university on the Knowledge Gateway. We, as with all patent attorneys and advisors, we sit in the sort of juncture between helping people both, in front of the Intellectual Property Office and other ones, and just providing advice across the range, whether it be to do with obtaining protection, avoiding someone else's protection, or generally any IP aspects around it.
Stuart Coyle, would you like to introduce yourself from Innovate UK Edge?
Yeah, thank you, John. Yeah, so Innovate UK Edge is the helps SMEs in the East of England on their innovation and growth journey in a number of ways. Obviously covering investment, covering innovation management, and funding, but also, of course, importantly, IP readiness, which is a key part of the innovation journey. So I will be bringing that perspective from IP on the ground, plus a little bit of my previous experience of supporting companies as they enter international markets, and protecting their IP and asserting their IP in advance of that. And
finally, but not least, Joe Simon Brown. Would you like to introduce yourself from Kemp?
Yes, thank you very much, John. So I'm a patent attorney also, same as James, but I work for a firm called Kemp, who are a relatively large firm of patent and trademark attorneys. We've got offices scattered around in London, Cambridge, Oxford, and Paris, and I'm based in our Cambridge office. So I mainly focus on small startup SME clients in the wider region.
What is intellectual property? And I'm going to ask that of Emma.
Intellectual property is a collective term for intellectual property rights, which include patents, trademarks, registered designs, copyright. There are other elements that are unregistered, such as confidentiality and trade secrets, unregistered design right, non-disclosure agreements, all that kind of thing, up your intellectual property policy. But if we're talking about it in its simplest form, it's probably easier to just pinpoint the individual rights that you can register. So probably the easiest way of describing it is to think of an everyday product that we all own, and I'm going to choose the mobile phone because hopefully we all by now own a mobile phone. So with a mobile phone, the technology behind how that product functions will be protected by a patent. The patent protects the invention of it. The branding, so your Apple and your Samsung, would be protected by a trademark. With the copyright is an automatic right. So the way things are displayed on the screen would be protected by copyright. Any apps that actually come up on your phone are protected by copyright automatically. And the registered design of the phone would be simply the aesthetic appearance of it. So in its simplest form, obviously there's a lot more complicated issues around intellectual property and a lot more nuances around it. But in its simplest form, that's how it is in a nutshell.
How long does the patent actually last?
A patent lasts for 20 years, so you have a monopoly. There are some patents that last a little bit longer in some fields, but in a general sense, a patent lasts for 20 years and you can't renew it after that.
Which countries does the patent actually cover? Is it just the UK, or can you get patents for other countries?
You can, but IP is territorial. So if you apply for the UK, you will only have protection in the UK. If you want protection in other territories, you will need to apply to those territories. If you've got a patent in the UK, it does prevent anyone else having a similar patent, but it doesn't prevent them from creating that product. So if you want the ultimate protection in other territories, then you would need to apply. And there's a number of different ways in which you can do that.
I've got a question for James here, and it's come from the audience. Our startup has a trademark registered in the UK 2 years ago, but we're now ready to launch our company, and this will involve selling product covered by the trademark in international markets, especially the USA. Can we register the trademarks in the USA claiming priority from our UK registration?
Simple answer, no, because the period of time for claiming priority on a trademark is only 6 months from the filing date in the UK. However, unlike the situation with patents, priority is not essential when it comes to trademark registration abroad, because the trademark, an application can certainly be filed now to register the mark in the US or elsewhere, and the pre-existence of the UK right is in no way detrimental to the attempt to register in the US. Obviously, it will be judged as of the date in the US and the rights that exist in the US at the relevant time. And in fact, particularly for the US, it's slightly unusual for some other countries, the fact that you have a registration in the UK is of some benefit in terms of the process of getting a US trademark. It avoids the need to prove that you've used your mark in the US before you go to registration. So you can still get it, but you can't claim priority.
I've got another question from the audience here. Joe, perhaps you'd like to pick this one. Do you think that people tend to think that IP only means patents and they forget about trademarks, copyright, registered designs? And maybe they're more likely to infringe a trademark by accident rather than a patent, for example?
I think patents probably are one of the intellectual property rights that most people know about. Certainly if they're working in technological fields, then they will be aware of patents. And perhaps some businesses do forget about the others. I think certainly registered designs in particular is probably a registered right that is less commonly known about, but it can be very effective and is certainly more cost effective than filing patents. So just briefly on that, a registered design protects the aesthetics of a product, whereas a patent covers kind of the technical aspects of how it works. So yeah, I think for any business, it's important to consider the full spectrum of your IP, patents, trademarks, registered designs, copyrights, trade secrets, are all important considerations, and they all have their place in the business. On to the second question, is a trademark more likely to be infringed by accident? I mean, that entirely depends on the business, but quite possibly, you often get branding conflicts. In fact, you know, there's been quite a bit in the case law recently. One, I think, between Huawei and Chanel, where so Chanel, you'll know, is the 2 C's, but Huawei's symbol looks a bit like the 2 C's. If you flip it 90 degrees, it's an H. So there's a bit of conflict with that kind of branding, and that's not necessarily a conflict that would be obvious. So yeah, I think, you know, trademarks, you know, you can run into problems, but the way to get around that is do a good search beforehand. Make sure that your, you know, the trade name and the mark that you're hoping to use on your branded product is free to use in the markets of interest. And obviously people like me and James can help with that kind of thing.
from my perspective of working with startups and SMEs at the front end, yeah, it's a really valid question. That first question, people maybe shy away or don't get to think too much about the IP because they do often assume it's patents, trademarks, and it might not be practical for a lot of companies that are, you know, running on a tight budget anyway. These issues are not practical. So I think other types of IP, as mentioned, company secrets and so on, are really important. And even larger companies, of course, like the likes of Coca-Cola and Heinz, rely on those. But it's worth. This is why it's important to have a view on IP from the very start in terms of what potentially is registerable, and what can be protected in other ways, and have the beginnings of a strategy from the start based on, you know, and go and get as much advice as possible within budgets. But yeah, the range of IP is much wider than even just trademarks, copyright, registered designs, and certainly discussions about what else is potentially protectable, and how are really worthwhile at an early stage.
I mean, it does raise the question. There are 5 major types of intellectual property. Can the panel actually tell me what those 5 types are?
Patents, trademarks, designs, copyright, and registered rights. So
it's quite wide ranging. This is the point. It's where do you actually start?
Yeah.
So when should someone actually start looking at IP or those 5 categories? When's the best time to start looking? Is it once you've started selling? Is it before you start the business? When would you do it?
As early as possible is the answer. So some of the rights, patents in particular, are very time critical. You know, if you disclose your invention publicly, that precludes you from obtaining a patent and protecting your invention. So it's very important that patents are considered at an early stage before anything becomes public. But there are also similar considerations for other rights, like registered designs, trademarks to an extent, but as James said, priority isn't such an issue. But certainly very early on, you should be thinking, and especially when it comes to branding, you know, if you're too far down the road of spending money on branding, and you suddenly realize someone else has a trademark, you're in trouble.
As Joe said, think about it early. Always think early. It may be that thinking about it allows you to just understand what you should be considering, and therefore what are the mileposts that lead you onto a relevant stage. So, for example, understanding on a developmental one, which slightly leads on to a question, one of the ones that's there. If you're starting a project to develop something, until you actually have created something that might be filed as a patent application or other form of IP, you obviously can't file it, but you need to make sure that you've thought about and understood the steps that you will need to kind of follow so that you can feed it into doing it at the right stage. So part of it, like there's early strategy understanding, and then a clear timeline of you know, the key steps and doing it at the right time. So always early, because you can always go, all right, now I've got a bit more time on that particular bit. But it's always when people come and say, I've done this and I did that, and you went, well, too late now on that one. It's always better to know first.
Yes, I suppose this really could apply if you're using some kind of technical aspect of something and applying it into a different environment. Are you infringing someone else's patent by doing that? Are there any observations on that at all? Any suggestions or ideas?
Yes, it's a good idea to be aware of what you're doing. If you think that you need to use some other aspect of technology that maybe someone else's, then it's obviously appropriate to have a look at what is potentially in place in terms of their rights, not least of which, because A, you don't really want to kind of fall foul of it, or it may be that you need to talk to them in terms of licensing. It may be that you can't get round it, but what you want to do is move on from it, and there may be some issue of licensing that is necessary, or it may be that what you don't want to do is the same thing. So you say, well, where are we in the state of the art? Let's have an understanding of that. Let's do some searching and identify it in order to move on from it, rather than sort of, you know, crossing old ground.
I've had SMEs come to me and say, right, we've developed this brilliant product. We know there's a market for it. Because it's related to our existing market. We're ready to launch it. I'll say, what's your IP? You know, what's your IP strategy, and where's your IP? What's your IP status on it? I'll say, well, we haven't looked at that, and they found that actually there are patents either domestically or abroad already existing. I mean, from a very simple competitive angle, obviously you'd want to be aware of what's out there already anyway. But obviously, when it gets into registered patents, then that's even more of an issue. And in terms of checking what's out there, and this is probably maybe more Emma's. Emma might want to add to this, but as a business owner with not a lot of experience of working with IP, I know the IP office does have some very useful tools for guidance and content around guidance on how to carry out initial searches. Once you get a bit more involved and you've got an idea of what's out there, you'll want to go to someone like Joe or James for professional support on that. But the resources there are brilliant. Also, of course, in terms of speaking to advisors who are helping your business to understand some of the areas you should be looking at, and signposting some resources. It's a great thing you can do early on in your business.
Another important issue is you know, how you go about conducting those kind of searches. And you know, you can search forever and still not find everything. You have to be realistic about the scope of your searches, and that will depend on your business, the markets you're looking at, you know, how narrow the field is, and so those kind of strategic considerations are things that need to be taken into account.
The trademark search is pretty straightforward in comparison to a SPASnet, which is the facility for searching for patents. I would strongly advise having some help in using a SPASnet, because, well, let's just say there's not going to be any plain English awards when it comes to technical language around patents. So I think you know, having that expertise is really, really key, because you're describing a product that doesn't exist, and how you're going to do that is not, you can't look for a table if a table doesn't exist. So it's really important to realize that there is specific language, and just searching on the patent database is not going to be as straightforward as you think it might. And that's for patents. Designs is another issue, because it's really difficult to search on the designs view page to use, and also that it is being updated. As far as the trademark search is in comparison, it's quite straightforward. So if you're simply wanting to protect the name of something as your business, you can simply search for that text. But just bear in mind, it's not a definitive search, it's a guide. If you search for that text and nothing matches it, that doesn't mean they're okay and you're going to be okay to have it. You still go through an official search. On the flip side, if you do search for text and something comes up in the same goods and service and the same text, chances are you're going to have a problem with that. So it could avoid expensive issues in the future. So I think you just need to be mindful of the fact that it's not a straightforward search. It's good, and it'll give you a kind of sense of other trademarks that are out there.
How long do searches normally take? I mean, how much time should you allow for a search?
It depends on what you're searching for, in which markets you're searching, if you're looking for domestic only or abroad. You know, there are professional searchers who specialize in patent searching, for example, and they would probably spend a day or two searching. But if you're trying to do it yourself, I mean, how long is a piece of string? It's a difficult one to answer. But my advice is you'd always get a better quality search done by a professional, i.e. a professional searcher. You don't necessarily need a patent attorney to analyze those results in the first instance, though that would be recommended. But yeah, as Emma mentioned, patent searching can be tricky, so I'd probably want to rely on a professional for anything that you really needed solid answers for, or more solid.
In terms of timescale, if you're thinking I need something looked at, it's not, the timescales are not huge, but there is a realistic period of at least days, and in reality it takes a bit of time to do the stuff and get it back. But it's not, we're not talking about, oh, I need to have thought about this months in advance, nothing like that.
It's a lot quicker now than it was 20 years ago. That's the point.
Yeah, indeed. Yeah, access to information is there, but obviously, and analysing and digging through it still takes a fair amount of time.
Yeah. The information is more readily available, but there's more of it. So that's the problem. So James, whilst I got you, if a UK patent is applied for, would confidential information be accessible in other territories?
When you file a patent application, nothing is available for 18 months until the application is published. So, and that applies, generally speaking, it's the same everywhere. So there is a period between the filing of the application and its publication, at which point anyone can access it, of 18 months from the earliest priority date. So the answer, so initially, absolutely not. Now, the question then of confidential information, if that means what's been put in the patent specification, then yes, that will be available when it becomes public, and it's unavoidable. It's an inherent part of the deal, if you like, between the government and the inventors to say that you get protection in return for disclosure of sufficient information. So it's an unavoidable consequence, but confidential information doesn't have to be put into a patent application. If it's truly confidential and should stay confidential and is not required, then obviously, people like Joe and I would not put it in, because there's no need to disclose it unless there is a need, if you see what I mean. And if there's a need, it's not really confidential information in the long run.
Is there too much emphasis placed on patenting, and really businesses need to consider whether it is appropriate for them? For example, lots of innovators setting up businesses based on a new idea rush out and spend a lot of money on obtaining a patent before they understand how big their market is. In many cases, the size of the market doesn't justify a patent, as there won't be a rush of competitors, and even if there was, the new business couldn't afford to defend the patent. The money might have been better spent on building the business.
And it's definitely not appropriate for everyone to get a patent. It entirely depends on the business. As with any intellectual property rights that you might obtain, they are there as kind of business tools to support your business. You don't need to use them if they're not appropriate. As with anything in business, you have to think about costs. And you have to make your decisions, based on what's best for the business. And part of that is how much money you're spending. And if an idea doesn't have, great legs, and you can't really justify spending the money on a patent, then of course it's not appropriate for the business. But that said, because filing patents is something you need to consider very early on, you need to be aware that whatever decision you make could, stick with you, whether your business peters out or grows into, some massive multinational business. So you have to be aware when making that kind of decision not to file or to file. But certainly you should do what's best for your business. And seek advice that's suited to your business.
I think even Joe mentioned multinationals there. I was thinking even multinationals with large IP teams are looking all the time at which patents they maintain, which patents they drop, and so at every point of your growth of your growth journey, there is a question about, well, what patents are worth protecting, maintaining, expanding into other markets. Are there adjacent patents we should acquire, etc.? It's an ongoing thing that starts from day one.
Anything I'd add was just to sort of follow on from Joe's point about it's an early stage decision. So all of the bits of information mentioned in the question about it would be great to know those. It's just almost certainly you won't and couldn't know them until such point in time as you're past the decision point on filing the patent application. So I often liken filing patent applications. Any IP is a little bit like playing a game of poker commercially. But if you don't have any cards, you're not in the game. So you have to choose whether you're in the game or you're not in the game. And that is a business decision, but it's not always appropriate, but it often is. And you've just got to take a look in your crystal ball sometimes.
What if something becomes public against your will, like a leak? Are you still too late to patent it, even if you're able to pursue legal action?
I would say, how was it leaked in the first place? Obviously, even at an early stage of an idea, you need to be very careful about how you're sharing those ideas, and any information you're sharing with maybe potential suppliers or distributors or just other people can be, if it's on record somewhere, then that could be detrimental to a future application. Again, I'll leave the technicalities to the rest of the panel, but protect that information early on. If you do have to share information, get NDAs in place. They're not hard and fast solutions, but they're a signifier of what if they're written correctly. And again, you would probably need professional help for this. They're a signifier of what information should be protected and shouldn't be leaked. And if it's gone past that stage, that's already a mistake. And then in terms of remedying that, I will hand over to whoever else wants to take the baton on the panel.
The answer as to whether it's prejudicial from a patent point of view is it depends on the circumstances of that disclosure. Because if it was, I think as you were driving, actually, if it's a disclosure, if the information has leaked out inadvertently because you weren't very careful about it, then there's really nothing you can do about it because the information is out there and it's a relevant prior disclosure. Now, there are certain safeguards, and they're not great, but there are certain safeguards for information that's disclosed in breach of confidence, and patent applications filed within, at least I don't know, 6 months, is it? Joe, I'm losing track, is it still 12 on the breach of confidence? But anyway, there is a period within which if you can file a patent application and you can demonstrate that you can prove that it was in a breach of confidence, you may still be able to avoid that being a problem. You can effectively sort of claim a priority in advance of it. But it's a situation you don't really want to be in because it'll make it that much more expensive and complicated. It's protect that information and then file early. If you can possibly file early, there's always a nasty balance with filing, which kind of leads on to the previous question, is the earlier you file, the safer you are from this sort of thing happening. But the sooner the process is running and the earlier you are in terms of deciding on the viability of it as a project. But it's that difficult balance you have to strike commercially. So
on the patent side, this does happen every now and again. You get a prior disclosure, might have happened by accident or on purpose. I see it relatively frequently with clients who are universities. An academic has published a paper and they say, oh no, I needed to have filed a patent on it. And in those situations, as James said, there's little you can do, but some countries, not the UK, do offer grace periods for disclosures by inventors or applicants. So you could potentially still get protection in key markets such as the US and Japan, just to name two big examples. So there are remedies available in certain circumstances, but absolutely you need to keep things secret until such a time as you file the patent or if you've made the explicit decision not to.
You mentioned academic papers, for example, and another area which most people wouldn't think of is marketing. I mean, if the marketing team's not aligned and they've released information about the product in good faith, and it gets out there obviously before the right registrations have taken place, then that could be very damaging. And a related aspect of that is employee contracts or third-party contracts. So employee contracts would be an obvious one where company information and IP created within the company, which is another question, is protected by the contract. But people forget about third-party contracts. So, for example, if you find a freelancer off of Fiverr.com or a similar site, obviously Fiverr.com would have solid contracts, but some freelancers may not have solid contracts which officially transfer the IP to you once the contract is completed. And so you could end up using a logo that you got for £10 at the start of your company, and 5 years later find that you don't actually own the rights to that logo, in theory. So those are a couple of smaller issues in theory to look out for, but which could have a big impact.
Will Brexit complicate existing European IP agreements going forward?
In terms of your administration, we've kind of sorted all that out for you. So if you've got existing trademarks, for example, in Europe, historically would have included the Europe as part of that registration. We will have divided those into two different into two different registrations. So you should receive a registration certificate from us as a UK office, and then you have a separate registration for Europe. And then when it comes to renew, you'll need to renew in UK and you'll need to renew in Europe. And the similar system exists for registered designs as well. Copyright has its own rules. It's a universal right anyway, and there are no registers for copyright in most countries around the world, officially anyway. There are some official registration registers in some countries across the world, but the Berne Convention kind of governs all of the universal right in terms of copyright. So that should cover you there. And there wasn't a European patent anyway. There is a European patent process, which is similar to the PCT process, but for Europe. So with one application, you can select the countries you want protection in, and that still exists. There's been talk of a European patent for a number of years. So anytime now, really.
You've used the phrase trade secrets a couple of times in the answers. Can you explain what is meant by the term and how to protect the secrets, or is it just due to the name?
Basically, you have a choice whether to go public, not as was explained earlier. The moment you register a patent is published, of course, it's freely available information to anyone. Of course, it's then protected by that very nature. A trade secret is relying on the fact that you're not having to publish anything. You're keeping that information in-house. And the upside, of course, is that if anyone wanted to copy it, they have to put in a lot of time and resource to doing that. The downside is that obviously it's less obviously protected, and it's harder to then demonstrate that that you were first with that. Big companies use it, as I mentioned earlier. Coca-Cola, KFC with the herbs and spices, and Heinz are some of the obvious examples. But I think in technology companies, obviously it's a bit harder to know where there are trade secrets because of the very nature they're not made public. But technology companies will use trade secrets a lot in terms of the way their software is written, and also add maybe slight red herrings within software code to be able to keep it a trade secret. So adding a bits of superfluous code to keep it a trade secret, but then later on have some recourse to say, look, this has been copied because you wouldn't have normally designed this into the product.
There are trade secrets per se isn't protection. A trade secret is something that you merely don't disclose. It is secret, and the fact that whether you thought of it first or you didn't think of it first isn't really relevant, because if someone else knows it because they've worked it out themselves, there's no recourse to stop them because it's not protected. So it's a question of keeping that information to yourself to give you that competitive advantage. But you're always balancing. Now, sometimes there are things as simple as if you've got skilled people who know how to, say, set up a process or a bit of equipment, and they know how to do it, and it's that skill, and they can maintain that knowledge secret. That advantage to them is incredibly useful, but you don't disclose that because otherwise the other people may work out how to do it. So that's its function. But as soon as that information gets out there, it's out there. And if it's, as I said, if it's thought of by someone else, it's out there. So it's a control mechanism. Not everything is suitable, but it can have a lot of value if you can control that appropriately.
Whether you can use trade secrets to your advantage or not is kind of in many ways out of your hands. If it's something that's going to be made public anyway, when you put a product on the market, obviously you're not going to be able to use trade secrets because you know, your product can be reverse engineered and you know, your invention is going to be disclosed. Where trade secrets can be very powerful, as James alluded to, is when there is some aspect of know-how. For example, you know, a practical example, one of my clients, they make big metal canisters for burying nuclear waste. Okay, and these need to be incredibly smooth so that they, you know, they don't corrode. And they have a special way of making it very smooth. That is something they decided to keep secret and in-house because, firstly, you know, there's no way you could reverse engineer that. It's something that they could keep secret. Added a lot of value to their business over competitors, but also they were able to put things in place within their company to maintain secrecy, and that's very important when it comes to trade secrets. You have to have proper procedures in place for keeping those secrets and basically having, you know, disclosing information amongst your employees on a kind of needs to know basis. And you need those special provisions in place.
I had a client once that provided a hipping service. Now, hipping is where you take a piece of metal and you put it under extreme pressure and extract all oxygen from it. And it's used in deep sea activities, you know, laying cables and pipes and especially valves at the bottom of the ocean where they're under extreme pressure. The actual process of hipping is not an exact science. So therefore, every single one they did was actually trial and error. So you couldn't actually patent the process, and that was the problem. The company had no value because it had no means of actually demonstrating how that process could be actually patented. But I suppose the actual outcome itself was patentable in that way. So is there ever a time where it might actually be better strategy not to get any form of protection?
There is a time, but more often than not, you will want some form of IP registered, whether it be trademarks, designs, or patents.
Mm-hmm. Because when investors look at a business, of course, one of the questions they ask is there any IP? Is there any protection for what I'm investing in? Because obviously they want to invest in something that's going to have value. So we always regard IP as a tangible, if you like. It's something that it's got a label, it's tangible, therefore it has a worth, and you can calculate a worth from that. So that's something to bear in mind when you're going forward. How did Microsoft, Apple, Google, etc. protect their IPR in the early days?
You know, like anybody in the early days, they'll have started with what they've got, and they would have taken decisions about what to protect, how to protect it, and when to spend the money. And when they didn't have much money, they'll have spent it wisely, one hopes mostly, on what mattered. And as they grew and as they, you know, the value to them increased, they will have spent more. And obviously, they spend an awful lot now protecting things that, in reality, they wouldn't have tried to protect when they started, because it just simply wouldn't have been anywhere near on their budget to try and do the things that they now do in comparison. So it's not an easy question to answer definitively, but they will have started like anyone else by focusing on the stuff that was most commercially justified, that either gave them the relevant edge or presented, you know, coming back to your point, John, about investment, that built something that allowed external investment to build the company. These are all factors, and it doesn't really change. So there are lots of things they could have protected, but my guess is some of the things that people think they did protect, almost certainly they didn't.
Joe?
Yeah, it's probably worth saying that, your IP strategy and what you protect, is something that evolves constantly with the business. Something that is, a value, to the business at the start isn't necessarily a value at the end, and vice versa. As James said, taking these examples of companies, they will have started off with a narrow strategy, protecting only what they could afford to protect, which could have been very narrow and very important things, whereas now they have a scattering of patents in covering all sorts of different technologies, and often the same technology in all sorts of different ways.
Whilst we're on the subject of Google and Apple, people like that, and Stuart actually mentioned software in passing. How can you protect software? Is there any way? Is it just beyond a trade secret?
I was just going to make the point that Microsoft, Apple, and Google are interesting as well, because obviously they're pretty much, I don't have the figures, but pretty much most of their value these days is arguably IPR in some form or other, because they don't manufacture. So it's all based on trademarks, designs, obviously patents, and so that is a key part of the value of their business. But in terms of software specifically, I believe there are different. I will defer to the IP professionals, but there are different guidelines in different territories. I believe in the UK, software per se can't be copyrighted, but it can in the US. Is that the right way around?
No, copyright applies to many things in relation to software, source code, all those things, and it's automatic. So there is copyright protection in relation to software, but obviously that is the software, if you like, that is the code, and that's not what it's doing. So people often think in terms of the software, what is it achieving? Well, that isn't really related to copyright in any way. Patenting of software in the UK per se is not permitted, but there are, you can attempt to protect effectively software implemented inventions as long as the technical aspect achieved by the software meets the criteria. So you can't say it's a piece of software, it's patented. It's not, but if it achieves some sufficient technical outcome in the real world, then it can be patented by sort of slightly circuitous route. I mean, it's a bit of we could talk about it for hours, but I mean, as a brief summary, that sort of covers it. And yes, territorially, it's a bit different. It varies a bit in terms of the way that patentability is judged.
Fundamentally, the exclusion of software per se is actually quite narrow. So you can protect all sorts of software-based inventions, provided they have they make some technical contribution beyond just the software and the code. So yeah, I think it's probably a misconception that you can't patent software. In more cases than not, you probably could. It just has to have some technical nature to it. So you can't protect software that just does routine, admin, businessy type things. It needs to do something technical. And we could argue for another hour about what technical means, but
is there actually a best practice model? Is there an established route that people should follow when commencing a research project to potentially protect an undiscovered activity or foreground or something?
As to is there a best practice model, I don't know if someone's written one down, but the bottom line is yes, but it really comes down to a question of making sure that you have dealt with the framework and the control of the information. Sort of ties back to the questions about disclosure. So if you're setting out on a project with the aim of achieving something, obviously there's nothing you can protect until you've achieved it. But what matters is, depending on how the project is set up, that, for example, if someone is aiming to achieve it, it may be that there are contributors from a number of different employers or individuals or consultants or whatever, and therefore it's very important that the framework of who is going to own the IP that results from this project, that is all clear. It may be straightforward. It may be that, I set my employees in the research department on a particular project. They're all employees. It's all very clear that I own it. If, however, there are outside people or people that are not employees, or there's some other complication, it needs to be clear how it's going to be owned. So that's a framework, which may depend who comes up with it, may depend on the parameters of doing it. And the other aspect that's important in terms of to think about in the early stage is, depending on what it is, make sure you keep appropriate records of what you're doing and when you do it, so that if it's necessary to understand who invented what and when, that it's traceable in a sense of understanding the contributions made by different people at different times, so that you've got a clear picture. Right, we started from this, we got to this, who owns it, who are the inventors of it, and where does it flow from that point? So if you like that, the model is make sure you've got your framework right.
At the outset of any project, you know where you want to end up, and you can hopefully foresee any kind of potholes there might be along the way. And as long as you have things in place, such as making sure you record things, making sure you have agreements between collaborators in place, then you can go along smoothly. But yeah, just get all your ducks in a row before you crack on is probably the best thing.
Have a plan. A plan to succeed, as they say, because no one ever has a plan to fail. Let's have a plan to succeed. I think that works quite well. And now, I've been told in the past that if you're working on Ministry of Defence technologies, that you're not allowed to patent them, because that means that they're open and your enemies can actually find them. Is that actually true or false, do you know?
I think it's partly true. There are certainly provisions in UK law and in national laws of other countries on things like defence-related inventions and also nuclear and things like that. In the UK, you need approval for a broader filing strategy, but as long as you file in the UK first, you're generally okay, because the government can then come back and say, no, we're not going to allow this to be published.
It happens in certain areas a lot, but it doesn't happen an awful lot in reality, because they're very, very controlled. If you wind it back 50 years, if you had the word laser in it, you were probably going to get kind of sucked into the relevant department. But these days, it's much more confined. I mean, technically, if I remember rightly, I mean, I have never had to come across my desk that had that issue. My understanding is that we as patent attorneys have an obligation, if we think it is appropriate, we should perhaps refer it and make sure it's not filed somewhere else first. But again, I've never had to consider that. So yes, it's true, but is it relevant? Mostly not.
And are there any restrictions on working with the NHS that you're aware of for patents and that sort of thing?
The statute and things are blind to that kind of thing. And I see all charities here. It comes down that kind of thing, and it comes down to the NHS's, own processes and how they approach this kind of thing, rather than any specifics of patent law.
I just want to throw in a very last question about actually going into new markets abroad, i.e. China and other places like that. How and when do companies protect their IP when they go into those kind of territories?
From the very start of talking about it, obviously I referred to NDAs earlier, which there are, which aren't so straightforward, because then you get into issues of what's the jurisdiction and what law are you using and so on, and considerations of convenience. But looking into foreign markets, first of all, you want to look at, you want to have IP as part of your strategy in terms of your launch strategy. You might be going to certain markets for commercial reasons, but also you need to consider IP aspects. So it should be part of that initial planning, and work. Obviously with the right NDAs in place, work with an advisor, or work with approach attorneys for a bit of guidance early on to make sure you've got your country strategy right. And then if you decide on particular countries, obviously you can pursue the professional advice of an IP attorney, and or use dedicated resources. For example, the IP office I know has a China practice, or in country, or the Department for International Trade as well can offer signposting on how to work with IP in specific territories. But I think the last point I would make is, obviously, as we all know, laws are different in different countries. So the best thing you can do is to approach a specialist once you decided which countries you're approaching.
I suppose if you're not in a position to protect your product from reverse engineering in its early stages, is there any sort of dissuasion, any kind of efforts that you can put into place to prevent someone from reverse engineering your product once you've actually got it into the market?
That must depend on the product and the skill of the person who can get hold of the product. But what I was going to add to what Stuart said about the strategy of filing board, it's very valid to have a strategy and think about it. But one thing to bear in mind, and that is timescales, particularly when you're looking at registered rights with requirements for novelties such as patents and, to a slightly altered extent, registered designs. You don't have, the question of timing is you can't launch a product here and then 5 years later decide that you want to get a patent in China for it. It doesn't work that way. You have specific priority periods, say, based on for a patent 1 year. So you need to have started whatever protection you might be pursuing in, say, China within the relevant period, or you will not be pursuing it there. You may have there are many other aspects of the strategy you might want to take into account, but it's always worthwhile remembering that you can't come back at any stage to think about it.
To add to that, it's not just patents and product copying and reverse engineering. Actually, there are a few cases in certain territories of trademark sitting. For example, distributors would work to bring in a product into the market and then register the trademark themselves in that territory, and then obviously try and sell it back to the original company. So that's another area where, again, it's from the very start. There's a time element of making sure you've got all those in place long before you're actually moving into a territory.
Does anybody come up with an insurance policy to protect IP or protect any of your IP things? There's lots of nodding heads. So is it advisable to take out that kind of insurance?
It's not a question of which there is an obvious answer. There are different forms of IP insurance available and different providers, and as with all insurance companies, quite variable provisions within what is covered or not covered. It's not a bad idea to consider it, simply because the presence of insurance in relation to certain litigation can be very helpful. But as with all insurance, it's amazing what exclusions exist when you come to it. So it's something worth considering, but it is by no means something that I would say is a definitive position for everybody. In fact, I'd probably put in it's appropriate for some people in some circumstances, but to think of it very carefully and be skeptical of it, perhaps is maybe too strong a word, but at least thoughtful.
Yeah, I think in the past, maybe 10 years ago, IP insurance was a very bespoke thing, and not many people were offering it. It's much more widespread now than it was, and also you can get better premiums than you could back then. So yeah, it is definitely worth considering, but as James says, it is not going to be appropriate for everyone.
So I'm going to thank Emma Richards from the Intellectual Property Office, Joe, Simon Brown from Kemp, Stuart Coyle from Innovate UK Edge, and last but not least, James Sanderson from Sandersons on our own Knowledge Gateway. Thank you very much indeed today. Thank you to the audience for sticking with us throughout this process, and I do hope that you've taken something away with you today. And remember, we are available at the University of Essex for all help and support in business-related and investment matters. So contact us at uez@essex.ac.uk.